welcome to our podcast. It comes to us courtesy of the Touro College Jacob V. Fuchsberg Law Center and the Touro Law Review. I'll be your moderator today, Professor Peter Zablotsky. I'm primarily a torts professor here at Touro. I also teach a few other things like entertainment law, sports law. So I'll try to put on my best cool jazz FM radio voice and use that to introduce our panelists, Professor Rodger Citron, who is a professor here at Touro, and as well as Professor Dooley, also a professor here. The general topic today will be some Supreme Court cases, or rather two cases that have been consolidated before the Supreme Court that deal with personal jurisdiction. But before we get into the substance, Professor Citron, if you could introduce yourself and tell us what attracted you to the topic and a little bit about your background.
Thank you. And I've been teaching at Touro Law School since 2004, and I've taught civil procedure every year, I think, except for perhaps one. And before that, I was a government attorney. When I came back to law school to teach, I became intrigued by civil procedure just in the course of, and personal jurisdiction in particular, just in the course of reading the cases and preparing to teach. Personal jurisdiction, it was heavily litigated for a period of time, and then the Supreme Court gave up. And so I wrote one or two articles about that. Under the Roberts Court, personal jurisdiction has resurfaced, as we're going to discuss, and that's why I'm with you today talking about the Ford Motor cases. Thank you.
So, Professor Dooley, could you tell us a little bit about your background and what attracted you to this topic?
Sure, thank you. I am a teacher of both civil procedure and torts, as Professor Zablotsky mentioned, and I've been teaching civil procedure for many decades and torts for about a decade. And I see both courses as of a piece, having to do with the civil justice system and making it accessible to people. And of course, personal jurisdiction is a big part of that, making fora available to plaintiffs who seek to get redress. And as Professor Citron mentioned, in the Roberts era, there's been a resurgence of interest in personal jurisdiction in topics that many of us thought were quite settled, which we'll talk about later today. So the Ford cases give us a chance to explore the entire doctrine of personal jurisdiction and how it fits with a broader narrative about accessibility to justice.
All right, thank you. So again, the topic for today, in very general terms, concerns some consolidated cases before the court that, at least in the tort context, have the potential to even further narrow the law as it relates to personal jurisdiction. So just as a way of getting started, Professor Dooley, if you could really, almost from a torts perspective, just tell us the question first-year law students sometimes dread. What are the facts that set up these jurisdictional issues?
Yeah, and interestingly, these two consolidated cases are the sort of tort litigation that you might consider to be garden variety or bread and butter cases. Pick your metaphor. They both involve car accidents in which the plaintiffs ultimately alleged that there was a defect in the vehicle they were driving that caused their injuries. So in one of the cases out of Montana, the plaintiff was driving a Ford Explorer, and there was a wheel issue, a tire issue that caused the Explorer to overturn. The plaintiff driver was killed, and the estate is now suing. In the other case, the plaintiff was a passenger in a Crown Victoria, another Ford car, in which the passenger side airbag did not deploy. And the plaintiff was pretty severely injured, had neurological injuries. So again, these are not exotic cases by any means. These are not exotic fact patterns. They are cases that you see all the time. The important thing for our purposes of discussion here today is that each of these plaintiffs was a resident and citizen of the state where the accident happened. And like most plaintiffs, they preferred to sue at home. So that's what they did. They sued Ford Motor Company at home, which was also the place of the accident in each case.
All right. And Professor Citron, given that, sometimes a question that law professors dread because it's deceptively difficult. What are the basic principles of jurisdiction that are relevant to these this consolidated cases before the court?
So these cases involve, as we've said, personal jurisdiction, which is the court's power over the defendants. In first-year civil procedure, we start generally with jurisdiction. Important to distinguish subject matter jurisdiction, which isn't at issue here, right? The court, the federal court's ability to hear the case. That's not what's going on. Instead, we have Ford Motor Company, the defendant, saying, I can't be sued in Minnesota or Montana over claims arising out of the accidents that occurred in these states. And so when we teach personal jurisdiction, there are two categories. They hearken back to a 1945 case that everyone who ever took civil procedure will remember, the International Shoe case. Even Justice Alito, in our oral argument, right? He harkens back to, the middle of the last century and the International Shoe case. Shoe sets up two categories of personal jurisdiction. On the one hand, what these two cases are about, specific personal jurisdiction, right? That the claims that the plaintiffs are asserting arise out of or are related to events that occurred in the forum states, in the states where the suit was brought. What is not at issue, but is still lurking, as we're going to discuss, is general personal jurisdiction. The idea that the defendant is so at home that the defendant can be sued in the forum state, regardless of where the underlying events occurred. So these are specific personal jurisdiction cases. And as Professor Dooley said, they're fairly typical cases. The courts below ruled in entirely expected or anticipated ways by saying that Ford Motor Company, you sell cars in these states. Therefore, there is a connection or a relationship between your conduct sufficient for the court now to hear this case or each case brought by each plaintiff in Montana and Minnesota, respectively.
Okay, so based on my limited knowledge of civil procedure, but a little bit more expansive knowledge in products liability, I would have expected these rulings from a torts professor's point of view. If I'm teaching this case, I'm focusing on tort substance. It doesn't even occur to me that there might be some new jurisdictional issue, which you've highlighted. And Professor Dooley, it seems that if I understand things correctly, Ford is trying to use the tort concept of proximate cause by some kind of import or some kind of analogy to say that there is no specific jurisdiction. Could you explain, as you understand it, what Ford seems to be arguing, but again, from a proximate cause perspective, based on your experience with torts?
Yeah, that's a great question. And I think part of the problem is that the importation, as you put it, and that's exactly what it is not a perfect fit. And so in torts, as we know, that we talk about two different kinds of causation. We talk about factual causation and proximate causation. Factual causation typically defined by the famous but-for test. But for the defendant's conduct, would the plaintiff have been injured? And proximate causation is defined by the concept of foreseeability. And the argument that the Ford Motor Company is trying to make in this case is that there is not a sufficient causal relationship between Ford's actual conduct in the state where the plaintiffs are suing to justify specific jurisdiction, which, as Professor Citron just explained, has to do with the case relating to, which is the language we use, relating to, and sometimes the language is or arising out of the defendant's conduct. And they're really seizing on the arising out of defendant's contact with the state and really putting most of the linguistic emphasis on that phrase, because then, now here's where the tort intersection comes, because they're trying to argue that if the specific car that was involved in the accident in the state, let's just focus on Montana, in the state of Montana, was not sold to the plaintiff in Montana, was not made in Montana, was not designed or manufactured in Montana, then the accident in Montana in the Ford car does not arise out of, or really it's more to me of a but-for kind of idea, that it doesn't arise out of Ford's contacts with Montana and therefore specific jurisdiction fails. And on the other hand, the proximate cause piece defined by foreseeability is a much harder road for Ford to argue, because the idea that a car that they manufacture wouldn't end up in an accident in Montana or Minnesota or pretty much anywhere else in the contiguous United States is a little bit more difficult for them. So I think they're really conflating both factual and proximate cause, and just causing, and what they call it in the briefs is the causal requirement.
Okay. Well, so now, Professor, I'm sorry. No, I was just going to say, just for our audience, with that background, I suppose there are just any number of avenues for analysis here to discuss the significance, to discuss the ramifications of this. So now, really to the heart of the podcast, and in a sense, throwing it wide open. So please, both of you, starting with Professor Citron and going back and forth, just, give us any insight or reaction to what Ford is arguing.
So the one other fact that I wanted to add to what Professor Dooley just said is that Ford was very careful and selective in the cases that it decided to litigate this issue in. So one additional fact that I think is helpful is that Ford didn't sell the car directly to the plaintiff or the driver in either case. And that reinforces its contention that, well, as to the specific accident, as to the particular car, we didn't do anything in the forum state. There is no relationship or no connection between anything that we did and the accident that occurred, giving rise to the plaintiff's injuries. And Ford, it's really clever what Ford did, because Ford built on two prior cases that we teach in the first semester of civil procedure when we do personal jurisdiction. Ford leans heavily on one case, Bristol-Myers Squibb, that is a mass action, that is to say, a case involving many plaintiffs from a number of different states suing Bristol-Myers Squibb, a pharmaceutical company, on claims of product liability with respect to a drug that Bristol-Myers Squibb manufactures. But there's another case that we may not give as much attention to, but it's the Walden case. And it is a case involving individuals suing federal law enforcement officials. I think they were DEA officials, if I remember correctly, because as they were traveling home with cash, they were professional gamblers. The facts of the case are wonderful. The federal law enforcement officials seized the cash. They thought that this could only be suspicious, and eventually they gave the money back. But when the plaintiffs in the Walden case made it back to their home state, which I believe was Nevada, they brought suit. But of course, the seizure of the money took place in a different state, and the court in the second case in Walden said, no, the underlying acts didn't occur in where you brought suit. I believe it was Georgia, if I remember correctly. Bristol-Myers Squibb, just to go back and sort of close the circle on these two cases, there were plaintiffs from California bringing suit in California. They were joined by plaintiffs from other states. And what they all had in common was they had taken this drug manufactured by Bristol-Myers Squibb and joined together in a suit brought in California. And ultimately, the Supreme Court held California plaintiffs, you can proceed. That was unquestioned, that there was specific personal jurisdiction. But as to plaintiffs who purchased and consumed the drug in other states, there's no connection between what you did, what occurred, and California. So you cannot be plaintiffs in a suit against Bristol-Myers Squibb in California. So this idea that where we have a company that operates nationwide, in fact, worldwide, certainly sells products all across the United States, Bristol-Myers Squibb was this hook for arguing that state boundaries matter, and really focusing on, with respect to the underlying event, what are you suing about? Are you suing about something that occurred or took place, or the defendant's wrongful conduct that did occur in the forum state? And so it's very clever, I think, what Ford did, because its arguments follow from plausible readings of these two prior cases.
Yeah, it's I completely agree, but it's too clever by half, as the saying goes, right? Because the very significant difference in the Ford cases is that you have, from the plaintiff's perspective, someone who has never left home, who has bought a Ford product, who has, granted, the Ford product was originally sold to another party, but this person is involved in an accident in their own home state, and they're alleging that it's because of a defect in the Ford product, and they're not able to sue. So obviously the difference between these cases and Bristol-Myers Squibb is that the plaintiffs that were not allowed to proceed in Bristol-Myers Squibb had consumed the product outside the state and had been injured by the product outside the state. These plaintiffs were injured by the product in their own home state. And now if Ford gets its way, such plaintiffs in the future are going to have to go where to bring their lawsuit? Either they're going to have to go presumably to where the car was manufactured, or to Ford's headquarters. Basically, defendants get and control where plaintiffs can file lawsuits and products liability cases, when even for plaintiffs who have presumably never left home.
Mm-hmm. If I could maybe consolidate this, Coming back to you, Professor Citron, perhaps I'm missing something, always a possibility. But it seems like the plaintiffs in the Ford case are much more analogous to the plaintiffs in Bristol Myers who are from California. Right. So, I mean, I don't see why Ford isn't trying to somehow distinguish that case, because I could be completely wrong. I'm not sure the drug was manufactured in California, but it was used there, just as these Ford vehicles were used in the states, and the plaintiffs are bringing these actions in the states in which the products were used, and all completely foreseeable because that's where they're marketed. That's where they're sold. Even if these particular cars weren't, it's like suing based on where you bought this particular pill. I mean, that would seem like a very difficult case for Ford. Am I making any sense, Professor Citron, as I asked that question?
Absolutely. And that's why it really is important to recall that for Ford, it's a crucial distinction about where was the car originally sold, because the plaintiffs here were not purchasers and the passenger wasn't in a car with a purchaser. And so for Ford, that operates to sever the connection to the forum state, even though it's undisputed that Ford has sold and does sell cars to others in the forum state. And so Ford's approach is, it's part of the genius of it is that it extrapolates from a mass action case like Bristol Myers Squibb, right? We go from like a mass to a micro or a particular or individual case. And having done that, when they've narrowed the particular transaction, because this is one accident to one car, they then say, you can't connect us to anything that we did with respect to this particular car in the forum state. Can
I jump in? Sorry.
Yes, please.
I was just going to jump in and say, and here's where it's important, and in our conversations, Dean Citron and I have talked a lot about this. It's important to place this particular litigation in the context of the narrowing of general jurisdiction, general personal jurisdiction that's happened in a series of other cases that the Roberts Court has decided. So what makes, I think, Ford's argument too clever by half is that there is exactly what Dean Citron just said, that they're really now extrapolating that holding that you rightly point out, Professor Zablotsky, would seem bad for them in some ways, but they're saying, oh, but look, we now focus on this one particular car, and we did not sell this one particular car or make this one particular car in Montana or Minnesota. And so then you might say, yeah, Ford, but come on. You're a huge company. I can't get through the evening news without seeing one of your ads on TV. You're selling all kinds of cars in Minnesota and Montana. And they say, not relevant, because those are unrelated sales.
Okay.
And that would go to general jurisdiction, right? Ooh, but here's the rub. Meanwhile, general jurisdiction has been basically narrowed by the U.S. Supreme Court, arguably to only the headquarters and or state of incorporation, and maybe states where they have large manufacturing plants where you can say that they're at home. So in either case, plaintiff is out of luck if they want to sue at home where they had their accident.
Professor Citron, go ahead.
Yes, you can see this is sometimes what happens to me in class. I'm so excited. I can't wait to butt in. Here I go. And there's a couple different things going on that is in the discussion as well as in the case. And let's go back to 1945, and International Shoe. International Shoe was very much with the idea of due process and fairness, emphasized the notion of reasonableness. That is, the idea of, is it fair to the defendant in the sense of, is it so surprising or so burdensome for the defendant to be sued? Now, if we get beyond, right, take a slightly broader look at Ford's actions in these particular states, it seems inconceivable that it could say, we never could have anticipated or foreseen the prospect of suit in these states, because in the phrasing that becomes so important in these specific personal jurisdiction cases, Ford has purposely availed itself. It conducts business. It is successful in conducting business in these states. On the other hand, if that's the proper transitional phrase, one of the things that the Roberts Court has really done, and for people like Professor Dooley and I, who have started teaching civil procedure before Chief Justice Roberts was appointed to the Supreme Court, one of the things we've seen is in personal jurisdiction. Well, yes, there's the notion of due process, fairness. We understand that from International Shoe, but the Roberts Court has also really emphasized as an perhaps equally important or equally compelling or weighted principle or argument, federalism. And by that, state boundaries matter. And in our lifetimes as civil procedure professors, Professor Dooley and I have seen a phrase from Worldwide Volkswagen emphasizing federalism. We've seen it buried and then revived. And the Roberts Court has done the revival by saying that state boundaries matter. And so here is Ford sort of building on that principle to now contend, well, whatever else can be said about our conduct in these two states in terms of sales, advertising, indicia of purposeful availment, nonetheless, you can't lay a glove on us. You can't connect us to this particular car by anything that we did. And it is clever or too clever by a half. I'll stop there, but because that leads me into two different directions. But
Yeah,
I take a breath and let someone else talk.
There's so much to unpack here because obviously these cases are important to the individual litigants here who, as we described earlier, one died and the other was very severely injured. So we're talking real human cost here. But obviously they're litigating this up to the top because they are looking, I think, as an industry, and perhaps the defense bar, the corporate defense bar in general, to get to a situation where they can control in advance lawsuits of this, products liability lawsuits, and basically concentrate them in their home states. Mm-hmm. And so I just think it's really important to keep in mind the real world consequences of that for plaintiffs and what genuine choice will plaintiffs have to pursue the manufacturers. Again, of course, this is a jurisdictional question. We don't know that the merits necessarily will play out in plaintiff's favor. But if you can't even get to court, we'll never know. Mm-hmm. And it's a real concern, I think. And so I guess I'll introduce another word that the court doesn't really talk about in these opinions, and it doesn't really show up so much in the briefs either. The word is accountability. How will there ever be accountability if it's financially not feasible for victims of products liability product defect, I should say, to pursue their claims if they have to go to some far distant place to do it.
And I mean, I do want to throw it back to you in terms of unpacking, just as a quick interlude, just almost some random things that occurred to me as you both were speaking. I do think I'm going to start calling this Ford's argument the this particular pill argument, because that does seem to be what they're doing. Professor Citron, you talked about purchasers being a key fact. But interestingly, in tort law, especially in products liability, the law has really virtually abandoned any kind of purchaser requirement. I mean, not just privity, but, bystanders could recover. I mean, of course. So that's long gone in products liability. As far as international shoe being based on avoiding surprise kind of philosophy, kind of jurisprudential philosophy. Proximate cause does the same thing with superseding cause. Clearly, that's not present here. And the last thing I'll say is that, well, it is true that the Supreme Court of the United States, to the extent that it has an impact on products liability law, has definitely narrowed plaintiffs' options in any number of ways. That's sort of a whole course in and of itself, but they've definitely done that. But to throw it back to you folks, you said there is a lot to unpack. We have federalism, we have general jurisdiction, we have specific jurisdiction, we have proximate cause. So are there any other points or observations that occur to you as we start to bring our podcast to a close? You want to go, Professor Citron?
Yeah, I guess I have maybe 3 final thoughts. First, I would advise certainly law professors and law students too, the transcript of the oral argument, it's readily available. You can find it through any number of sources on the internet. And it's an interesting argument because you see the justices spinning out different hypotheticals, and as a way of trying to, tease out the implications of each side's arguments. The second thing is, and this is just my own personal reaction, as much as I have said Ford's argument is clever, because I do think it is clever, I also have this intuitive or visceral reaction of this argument can't be right. It can't be the case that even from almost like an equities perspective that Professor Dooley was talking about, it can't be fair to say to these plaintiffs, you have to go and find Ford in another forum. Now, lurking in the background for civil procedure professors and students is the Nicastro case. And I think that really animates some of Professor Dooley's criticism. But at the same time that I have this intuition or response, we have to note the court did grant cert, which is to say, had they wanted to leave the law as it is, they simply would have denied cert and left in place the decisions of the state Supreme Courts allowing the case to proceed against Ford. Now, it's entirely possible that the court recognized that there's this gap in specific personal jurisdiction law about what does this phrase arising out of a relate to mean, and it took the case or cases to explain that educational function that the court engages in to clarify the law for everyone. The last thought is what you see, or at least what I see over and over, is the court really trying to develop, a really helpful set of rules to help provide more guidance. And yet, it's such a frustrating task because the cases are so fact specific. This really is a common law body of law. That is, it really develops on a case-by-case basis. And so anytime I end up talking or writing about personal jurisdiction, I go back to an article written the year before I was born by Professor Jeffrey Hazard, where he calls these cases, personal jurisdiction cases, especially specific personal jurisdiction cases, a body of law of arbitrary particularization. And so, good luck to the Supreme Court in deciding the case and attempting to provide guidance. Like everyone else, I'm curious to see what will happen.
Yeah, and I would just endorse everything my wonderful colleague has said, and add just a couple of thoughts. One is that I really hope the opinions do take into account the whole panoply of personal jurisdictional law, and not narrowly focus on specific jurisdiction. In other words, I hope they see how this fits with the narrowing of general jurisdiction. Otherwise, I think we see formalism run amok, right? Then you get these two dead ends. And going back to what Dean Citron said about that, just can't be right, that the plaintiff injured in their own home state by the product in their own home state, then can't sue. Well, there's a dead end here with specific jurisdiction with a very sort of narrow reading of that line of cases. And then there's a dead end here on general jurisdiction with a narrow reading. I really hope that somehow the Supreme Court opinions bring that together. And the other thing I would say about the general jurisdiction line and the sort of narrowing there is it's very interesting to bring it to a very big jurisprudential debate. When you think about corporate personhood and the idea they're trying to analogize general jurisdiction for corporations to individual domicile for people, right? Should that be as narrow as state of incorporation and principal place of business, or as the corporate personhood seems to be expanding in other legal contexts, why wouldn't it expand here as well? And lastly, I would commend, if there's one opinion in all of this and it's a dissent, it would be Justice Sotomayor's dissent in Bristol-Myers Squibb, where she is really the only justice, I think, that brings together the concern, the real world and practical equity concerns about the concomitant narrowing of specific and general jurisdiction.
All right. Well, so much to think about. I hope we could reconvene once we have a decision and make some effort to unpack that. I thank you both for interested parties, both Professor Citron and Professor Dooley. They've written some very accessible articles, which I certainly need. They're rattling off cases and nodding. I know you can't see that, but I'm making notes as to what I have to Google so I can, have a little better understanding of this. Thank you both very much. And I hope we can reconvene for future topics or to discuss the opinion in this case.
To date. Thank you.
Thank you.